All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for March 24th of 2025. Brad, go ahead.
And shockingly, none of us are sitting in a hotel room at this very moment. So,
Yeah, that's right. It's
um,
been a while. It just seems like, well, you're still traveling. I'm traveling too, but
well, I'm back in New York. I'm in Syracuse right
no,
now.
well,
So,
I know, but
yeah.
I'm going to be in a hotel next week with you. Uh,
Yes,
so,
true, true.
so,
Okay. So, I got to tell you, there are some parts of this today which I am just going to rally on when we get to our third case. But for now, let's start in Charleston. We've got a firefighter who was transferred after he complained. And by the way, the transfer was to a station with no overtime or allegedly not overtime.
which I don't understand that. I don't. But
Yeah, I don't
I
get
take
that.
it at its face value, but
And maybe they're right. I mean, this is just a complaint, and I won't try to guess about why he
well,
says
and
that. But
the media's been reporting on this story too, and they've been saying he was fired, and I saw one head, yeah, I know it. It's like they don't read the lawsuit, but they said he was fired, and then another one said he was demoted,
okay,
and I
I
didn't
mean,
see any of that in the complaint,
I
but
don't see that at all. I just see he was transferred. But anyway, so here are the facts. Shocking you can't trust the news, but nonetheless, he makes a complaint to the union, and
yeah,
he complains. This is all allegedly, right?
mhm,
This is just the complaint.
right,
But he allegedly complains about unsafe working conditions.
mhm,
Primarily that it was like 90 degrees and there was mold where you had to sleep and you couldn't sleep and the bunk rooms are just unlivable, basically.
right,
It's a little strange, and I don't mean to say I doubt anything. It's just
mhm,
it's kind of strange. So this guy's an 11-year veteran.
mhm,
He's a member of the hazmat team. I guess he can identify mold. And he makes this complaint in July of 24. And I mean, that's really it, right? And he just complains about it. And then his captain is allegedly, I guess, instructed that he has to write him up for it.
mhm.
Um,
Well, not write him up for that. Write him up for something.
Something else, right? Unrelated, but effectively for this, right? So they're allegedly retaliating against him under another method, but for this complaint. And this is where we see a lot of, okay, I disagree with why I'm being written up for something else. So I'm going to attribute it to, oh, I didn't really do that. So I'm going to attribute it to this complaint, right? And you don't
Could
know, but
be.
that's what's going through in my mind.
Right. Sure. It could be. We do see cases like that. So, yeah.
Right. The part that you and I are scratching our head on a couple other things is allegedly, this station he's transferred to, he said there's not eligible for overtime pay
Mhm.
out of a station. That's strange and doesn't provide the same opportunities for overtime. Which is a term or condition of employment, but I don't
Mhm.
know. It's going to come back to why was he disciplined? Was it really true? Does this captain cooperate in this whole investigation on his side or on the department side?
Well,
It's
I think he sued. Now, you got to understand there's a big difference in South Carolina compared to Rhode Island, New York, and other states. And oh
God
man,
bless you.
my allergies. It's that time of year, and my allergies are really. We got serial sneezing going on here. I'm a serial sneezer. So, but what we've got is a difference based on South Carolina law. South Carolina law does not recognize unions. All right, so that's problem number one. Problem number two is there's actually, and I got to apologize for another sneeze. Excuse me.
Yeah,
Live TV, live video,
I
but
love it.
the I'm not sure if South Carolina has this. Some states, I believe North Carolina has it. They make it illegal for the city to negotiate or the municipality to negotiate with the union. It's not only not permitted, but
Wow.
it's illegal to do
Wow.
it. So yeah, so you've got that. And again, I can't speak specifically about South Carolina, but I know there are states out there that make it illegal to bargain with the union. So the union is more of a social organization than it certainly is a bargaining agent. But at any rate, there had been a long-standing series of complaints about the condition of this particular station and perhaps some others, and a sense that the city was not going to do anything about it, or they do it when they got to it, but it wasn't really a top priority. And I got to tell you, I've been to South Carolina numerous times, many times. My dad lives down there, but I've been to South Carolina in the summer, and it is not fun.
So 90-degree moldy things.
Well, it's humid, okay? Unlike Phoenix and Las Vegas, it can be 100 degrees, 110 degrees,
It's dry.
and it's not a dry heat. It is a wet, damp, humid, like just, put me in my air-conditioned room and leave me alone kind of heat. And so again, the allegation here is that the city was aware of it. There had been complaints. Out of frustration, this guy then goes to the union, and the union that prompts the union to call the fire chief, and then, all holy hell gets lowered on this particular firefighter. Now, so that's one narrative, and like you suggest, maybe there's another side to this that the city was working on it, and they really didn't need this guy to go outside the chain of command, but. In Rhode Island, in New York, in states that recognize collective bargaining,
that complaint would have been protected.
That's protected speech. Right. And so he doesn't have the benefit of those kind of laws. So what he's alleging now is two aspects of the First Amendment. First one is free speech, that his complaint to the union and then the union's advocacy on his part was protected by the First Amendment. So that's kind of number one. The second part is another. It's not directly in the Constitution, but it's been interpreted. It's the freedom of association, the right to work together for your mutual protection as a First Amendment right, and. They're alleging, or the lawsuit alleges, both a violation of the First Amendment free speech, but also the freedom of association. So, whether or not it's going to be enough, I would think a lawsuit like this would be more likely where someone got terminated and they have no other resort. For a transfer, First Amendment lawsuit over a transfer. And I'm not saying, I'm not taking sides in it. Maybe he's 100% right, and certainly on the facts as alleged, but a transfer?
Right.
So right. I don't know.
And to me, the captain's going to be the main witness. But anyway, we'll see what happens.
Yeah.
We'll see what happens.
And the captain could be a member of the bargaining. Well, there is no bargaining.
No, right.
Certainly, but the union does have representation of everyone, captain and below. So,
okay, let's go to Philadelphia, where, God, I hope this isn't true. I mean, this is just.
I can just see this happening.
Oh, God, I hope this is not true. I'm just, I hope it's not true. What can I say? So we have the estate, meaning the guy's dead, of a man who claimed that he called for EMS, and he did so by activating a medical device. The medics came, knocked on the door, and departed as he lays dying on the floor. This is all from April of 24, not even a year yet. And they basically just claimed that he, they walked away and didn't do anything. I have a hard time believing that's true, but I hope to God it's not true.
I got a couple of dozen lawsuits, same facts. And this is a challenge. I mean, I've been there on other types of runs, even like the smoke detectors going off. Okay. Do you break in? Do you not break in? Do we break in every single time?
No, and then, we learned that lesson.
You see what I'm saying? So, and then, the possibility of getting shot as well. Oh, you're at the wrong address and you broke into the wrong address, or the right address, but
but at least you get a 911 callback. The problem is you can't necessarily call back to every device. If your Apple Watch goes off, yes, it's connected to some cell signal, but it could be wireless too. And if your phone's not near you, if it's a different type of device where you're just pressing an alert, and yes, I know that creates a speaker, right? Maybe they can call back the lifeline. There had to be some sort of I'm hoping, right? After only doing this for 3 decades, they're like, nobody's answering the door. Can you make a reverse phone call? See if you can get them to come to the door. Maybe we we look in the windows, we look at the mailbox, right? You're going to the neighbors' houses. You're doing everything you can because somebody called 911. Now, one of the problems is we're seeing a lot of these false calls from electronic devices, like people leaving their iPhone on top of their car, and it sends this crash alert, right? Major crash because the iPhone shattered, and no, I left my phone on the car and drove away, and nobody's there. But we don't know. We don't know. I guarantee there'll be an investigation. I'm sure there already was an investigation.
There already was.
Yeah. So we'll see what happens.
When you and I talk about policies and we talk about liability, we draw a distinction. I think there's an important distinction, and it's important to me about preventing harm. And that should be the goal of our policies, to prevent harm. There's another goal of the policies, which is to prevent liability. And I think whenever you have a choice between preventing harm or preventing liability, you should prevent the harm, because then you prevent the liability. Okay? But in this case, I really think that fire departments need to have a policy in place for what to do in these situations. First of all, so that we do things right and that we prevent harm. But secondly, so that the medics in a situation like this are not left to the four winds, that they have guidance. And like you said, you do the 360, you try to find a way in, you check with the neighbors, you have fire alarm, double check the callback number, and you do everything you can. And then, after a certain period of time, if you can't and you're confronted with, I've got to do damage to get in, don't do damage, or do damage, whatever your policy is, okay?
Right.
But by having that policy, someone who wants to allege negligence has to allege that the policy was negligent.
Right.
Okay. And policy decisions are much more likely to have immunity protection than discretionary or non-discretionary or functionary decisions, ministerial decisions that individual medics make on individual runs. So there's an important, I think, connection, as I read the case, to policies. And there's a benefit to having thought through this, whether we're talking a medical run, whether we're talking about smoke detectors or alarm going off, having it in a policy. Okay.
Right.
That's my 2 cents on that.
No, and I think we learned a lot since the 2 firefighters were shot, right? For going to the wrong house. I actually had about 5 years ago, I actually had the opportunity to meet with the chief.
Was that?
No, that was the county in it was either Prince William or Prince George, and I always get the two confused, but it was either Prince William County or Prince George County.
I thought you were talking about the New York case.
No. This is not New York.
Okay.
No. This is Maryland, or I think it's Maryland, where the 2 firefighters go to the house. They knock down the door. It's on video, actually, and the guy comes around because he wasn't the patient shooting at him. The actual homeowner gets arrested for, I think, murder or homicide or something, because the guys are running away and he shoots one in the back. But I met with the chief after, and I said, sorry, obviously, and what happened, and what are you going to do? And he said, I'll tell you what we're doing. We're not knocking down doors anymore, except 4 situations. Smell of smoke, person inside screaming for help, right? Police verify, or somebody on the phone verifies. They said, but smells and bells, we're not going in. We'll look in windows. We'll do all these things. He said, we're not doing this anymore. They got rid of their police looking uniforms. They went to red shirts, no badges. So there were a lot of changes that we should discuss in policy, so that we're not knocking down a door, as you said, right? That we don't want to do that if we don't have to, so we don't get shot. But there are ways to react, but this is a policy measure. We should not have to make up how we react.
Exactly. And that's one of the benefits of a policy. You get 2 benefits that we just talked about. One is the potential for immunity protection. We'll put that one off to the side. But your policy should reflect best practices. They should be well researched. And a committee or whomever is going to be drafting the policies should be educating themselves on cases like that and incorporating the lessons learned there into the policy, so that people are doing things on a daily basis in the way that is the best practice for the industry.
Right.
Yeah.
Okay, this next one, I've been real calm for, but this next one, I am going to go ballistic as all hell. So I apologize to anybody except for the Socialist Republic of New York State. I do not apologize to them. So, but first I want to caution, I am not a racist. I'm just being clear. So listen to it before you say, oh, Brad's racist, which would be weird. But nonetheless, before anyone accuses me of this, I have a legal basis for what I'm about to say. And Chip Comstock and I, at my conference 3 years ago, did a lecture on this, and we said, watch it, it's going to come. And here it goes. So New York State, there's kind of two parts of this. 2/3 I agree with, one I vehemently disagree with. New York State has a list of questions you're allowed to ask applicants. And New York State also has a law that prohibits the displaying, and this is the main portion of the first part of this, symbols of hate. And the statute defines 2 symbols of hate. One, the swastika. Okay, maybe I'm a little biased, but I don't think anybody's going to say that there's any context under which displaying the swastika is not a symbol of hate. I'm willing to go with that. The U.S. Supreme Court may disagree, but we'll get to that in a moment. The next one is the Confederate flag. And New York State has declared that the federal flag is a symbol of hate. Now, here's the problem. The United States Supreme Court disagrees. The United States Supreme Court requires that for a symbol to be a symbol of hate, it must have the intent to place somebody in the fear of harm, violence, etc. So, for example, if I, in my law office, in my parking lot, want to put a big burning cross up in front of my building, it is not a symbol of hate. And people could be saying, how not? It's the Klan. No, because I'm putting it up and I'm not trying to intimidate myself. Now, you put it on a lawn of a black family. Okay, well, there's one purpose there, right? To intimidate, to threaten. Here's the thing. Brookhaven Fire Department, you and I did this last year at our conference, and 2 years ago it came up. They have a member, and I don't know if this was exactly the situation, but it is the same, that Brookhaven, because they're one of the defendants here, goes to a member's house. I think he was sick or something, but they paraded down there, and they have on the side of their truck their company logo, the historical company logo, which has the Confederate flag. And I have a lot of clients in New York that are called the Rebels or something else where the Confederate flag is part of the history. And they displayed the Confederate flag. Now, New York says, oh, you can display it for historical purposes if it's in a book, etc., right? But here, it's on a truck or somewhere. In any event, they claim the Division of Human Rights, an agency, claims that as one of 3 claims, we'll deal with the other 2, but one of 3 claims that they displayed the Confederate flag, and that's a symbol of hate. It is not a symbol of hate. But here, they settled. The state settled with these companies. Now, maybe it was worth it to settle because it doesn't necessarily mean they're paying money or a lot of money. It means they're going to do training and correct their practices, etc. But regardless of the way paid $1, $1 million, corrected practices or not, the Confederate flag is not a symbol of hate. Now, it may upset many of you to see it and believe that it represents a time of hate, but it is not, under the term of the law, a symbol of hate. Unless you're going to put it on a black family's doorstep, right, with the intent to intimidate, it is not a symbol of hate. I challenge
it's contextual. It depends on the context. It depends on the context of how it's used. And that raises a question in my mind, because even the SWAT sticker, okay? The SWAT sticker, I know there's motorcycle clubs that, utilize it, okay? And I don't know what message they're trying to send. But here's the thing. If I have a sign of a SWAT sticker, and superimposed over it, I have a circle and an X through it. Am I in violation of that law?
Yes.
Because and that's what I'm saying. And my intent is to say no.
Right.
But
you displayed it.
Okay. And this is where I think well-intentioned, a lot of people are well-intentioned, the New York State Human Rights Commission or whomever it is, well-intentioned, but misguided in how they're enforcing the law.
I would have fought this. I would have fought if the client gave me money and here you had 3 well-funded departments. I would have fought this to the U.S. Supreme Court because the U.S. Supreme Court already said it's not a symbol of hate. It needs the context, the message, the threat of violence. And in any event, I am so upset with New York State, but who cares? It's New York State. We are the socialist republic.
I think the term bye-bye might be appropriate here.
Yeah, it would be, or is. So but now the other two parts, I hate to do this, are the big, I told you so. So the other two parts are, one, on their application, and I still disagree with New York on one of them, even though I'm going to say I told you so. One is they are asking, let me get to it. Okay, so Confederate flags, one, they ask questions about alleged protected class. So here's the first part. I'm going to get to that in a minute. Let me deal with the easy one. They asked about arrest. Have you ever been arrested? I'm guessing is the question. You cannot ask that. You can ask, have you ever been convicted of a crime? Or do you have any pending arrests? You may not ask, have you ever been arrested? Because that presumes you were found guilty. You may not have been found guilty. You may have gotten rid of it in some way, but you cannot ask everybody from New York and pretty much everyone in the whole nation. You cannot ask, have you ever been arrested? You can only ask.
It is illegal in New York. It is inadvisable in those other states.
Correct. And I will venture to guess that at least 2/3 of those states, that is just per se discrimination to ask that question. But New York's a lot farther out there. It is definitely also federally, on federal applications, prohibited to ask that question.
Well, it's only prohibited if the person is not hired.
Right. Good point. But that's the easy part. The next part I disagree with, and I'm going to sound like a Republican here, but good for me. But the next thing and third thing they asked, which the Division of Human Rights took issue with, was they asked, are you a citizen? Now, here's the problem. A non-citizen can be a member of the fire department. But what is wrong with asking about citizenship? For example, if you are here on a temporary visa and you're going to be here for 6 months, why am I going to invest all of that money and training and gear into you when you're only going to be here 6 months? Now, could I get around this question and say, are you legally permitted to live here for the next 5 years? Or we could ask it a different way, perhaps. But to me, yes, non-citizens can be members of fire departments, volunteer fire departments in New York State, at least. I presume most places, or many places. But there shouldn't be anything wrong with asking it. It's a viable question. And I'm sorry, we're a fire department. Many of us who go to military bases and other things, citizenship, when the hell is asking about citizenship a crime in the United States of America? Except in New York, apparently. You can't ask if you're a citizen.
States, but again, I whether it's virtue signaling or whatever the legislature or that agency that came up with that, is trying to say, oh, we're enlightened, we're woke, and we're not going to discriminate. But we had a female firefighter from France. She was a firefighter in France. She was here for a year doing some independent work, and we were happy to have her, even though it was for a year. We were happy to have her. But another question might be, Are you a U.S. citizen, or do you have a green card? Do you have? Are you? That's all. That's all.
But you can't. You can't in New York, at least. You can't ask that, and that is insane to me.
I'm pretty sure if you're going to hire somebody, you have to go through some sort of a federal question that you.
Yeah, there's a form I-9 that employers fill out on citizenship.
Just saying.
But not again in the Socialist Republic of New York. So Anyway, I am so livid and not surprised at New York State, but that's a valid question for a fire department. Again, I'm not disagreeing on, have you ever been arrested? That one you can't ask, but I got to tell you, next one who wants to fight, and I mean this, New York people, next one who wants to fight the Confederate flag, I'm your guy. I don't care whether I like it or hate it. It doesn't matter. It is not a symbol of hate as a matter of law, except in our state, and New York State needs to be sent back and told you can't create any law you want, especially when it conflicts with the United States Supreme Court's longtime holdings on symbols of hate. This wasn't difficult to do. I did research. I found one other state with that same law, just one. So I don't know if any others do, but as of 2 years ago, one other state had it. Okay, well, let's stay in New York. Not that anybody wants to, but let's stay in.
You are, right? I don't think you are.
No, I'm here. I'm sitting right in Syracuse.
No, I know you are now, but
oh, no, got forever. No. I'm out. So here now, for all our viewers on YouTube, we are going to use a phrase, that disease. Now we know what disease we're talking about. Starts with a C and ends with, a couple other letters. But on YouTube, apparently we're not allowed to say it, or we're going to get our episode erased.
Hopefully with the change in administration, they've lightened up on that. But why take a chance?
Why take a chance? So we have a decision by the Appellate Division, the second highest court in New York State, regarding the C disease, and there was a vaccine mandate for members of a union, and it was ruled that the mandate was not grievable. And I'm going to kind of turn this over to you because this is really your bailiwick.
Because I'm very familiar with collective bargaining and stuff. Now, first of all, one of the challenges here is most collective bargaining is organized and structured under a state labor board for public agencies. Now, private entities go under the National Labor Relations Board, but most states are under a state, like here in Rhode Island, it's the Rhode Island. Now I'm drawing a blank on it, but it's basically Labor Relations Act, Labor Relations Commission. Okay, so and I'm looking at it here under this particular arrangement, probably because New York City is so big, they have their own board of collective bargaining. So you don't go to the state board, state labor board. Was the
PERB in this case.
Yeah. Well, there's a number of different names. It could be PERB, but in Rhode Island here, it's the Rhode Island, the labor board. So, but again, rather than having a state board, you have a city board, which to me raises some immediate conflict and questions right there. Right. But at any rate, because the city now is controlling collective bargaining as opposed to the state, so you've got the union now that has this Palomino vaccine mandate. All right. And now we've got the firefighters wanting to grieve it. Okay. And the city labor board, I'm always going to state labor board, but the city labor board rules that it's not grievable because it's a condition of employment. Okay, so that's an important term, condition of employment. And because it's a condition of employment, and by you not getting the Palomino vaccine, you no longer meet the conditions of employment, it's not grievable. Now, here's the problem. Collective bargaining inherently governs anything which is a term or condition of employment.
And how is this not a term or condition of employment?
They said it's a condition of employment. The board said it was a condition of employment. The Supreme Court said it was a condition of employment. The Appellate Division said it's a condition of employment. It's a condition of employment. How can it not be grievable? And again, I do question having a city agency overseeing this who is apparently paid by the same city that is seeking to have this non-grievable.
True. The only thing I will say is that agency and the state counterpart are so employee focused, not employer focused. In New York, employers are persona non grata. I'm shocked.
This is clearly
the opposite.
And maybe your Court of Appeals will take a sharp look at this. But I think under any other collective bargaining law that I'm aware of, this is certainly
grievable. Of course it is. I have nothing. I have nothing. But I will tell you, this is the same state as the rest of that other BS. This is the same state. This is my favorite part. And it's related, but not unrelated. So there's a big scandal now with the corrections officers. In New York, there was a death of an inmate, and corrections officers were attacked basically really for the death. And I won't get into that. But then they went on strike. Our corrections officers from the jails went on strike. They called the National Guard, all that stuff. And so here's what our fine governor did. This is amazing. Now, remember, New York is a very employer-friendly state. The governor said no other passed a law, executive order, something said no employee of the corrections department of docks is permitted to get another job with any other municipality in any other capacity. And she forbade any municipality in New York State from hiring them. There you go.
Isn't that the kind of
Same
things
state.
yeah, I'm going to say, isn't that the kind of heavy-handed thing that they attribute to fascists and
Yeah.
conservatives? And good Lord.
Yeah, well, that's New York State, and that's what people face in New York State when you go up against the we're here for the common working person. Yeah, except we're going to make sure you never eat again if you don't work for us. That is such a constitutional violation. And the funny thing is, New York State also outlawed restrictive covenants. So none of it makes sense. Anyway, I will get off my.
Here's the theme. Here's the theme. It's whatever I want when I want it.
Yeah.
You've got to give me whatever I want when I want it.
Yeah, and don't piss me off because I'm the governor of the socialist state. So, but it's funny, like people criticize me for being very down on New York, but these are the types of things, right? Because I said so type things. We don't care what the law is. We'll do anything we want. And you yell at one political party for allegedly doing that. And here, they're
doing it as a daily practice.
Oh my God, it's unbelievable. And our courts don't always help. Some do, some don't. Okay, so now we're going to go down to a federal court in Houston, where we have a firefighter filed 2 lawsuits. And this is another one you could probably do better than me, frankly, because we have a history of this. I don't know if you want to pick it up, or I'll keep going, or up to you.
No, go ahead. Let me catch up with it.
Okay, so I'll keep speaking and cut me off at any point. So a judge has recommended that. So a magistrate in federal court makes a very highly influential decision to the main judge. The judge then reads it and either adopts it or doesn't. But so we have, it's not a final, but we have a recommendation by a federal magistrate to a judge that this second lawsuit filed by the Houston firefighter be dismissed. So the recommendation is he should lose. And the lawsuit was over Title VII, and he's challenging a consent decree, which we'll talk about what those are quickly, that was in 12, I guess, that established a procedure for how promotions are done in the Houston Fire Department. And here, 7 Black firefighters allege that promotional exams for captain and senior captain were racially discriminatory, had a disparate impact. Whether intended, which is usually never the case, but unintended, right, is a disparate impact standard. We designed something, we tried to be racially neutral, but we messed up. Cut me off anytime.
No,
so
I got it here. I just kind of refreshed my recollection on it by reviewing it. And so you had this consent decree, and what the firefighter tried, I guess, initially in 2022, he alleged that the consent decree was invalid, or basically wasn't doing what it set out to do, and that he felt like it needed to be reviewed or maybe replaced with something stronger because it wasn't having the intended impact. That case was dismissed, and he subsequently filed a second case about a year ago, I guess, or no, I'm sorry, was it this year?
It was in...
No, he filed it in 2024. And the court got around to it. They're calling it, the firefighter's last name was Guzman, and they referred to the 2 cases. The first one that he filed challenging the consent decree as Guzman 1, and now he filed in 2024 Guzman 2, and the court dismissed that one based on basic principles of res judicata. And
can't argue the same thing twice.
Yeah. So, you lost the first one. How can, there's no difference here in what you're alleging. And this thing that kind of concerns me on the second one was that he filed it pro se. And, it's difficult enough for attorneys to navigate these complex constitutional issues. It's not like, a traffic ticket where you have some sort of informal ability to make certain arguments. When you're in federal court, you've got to hit all of the requirements, the procedural requirements of the court. and very difficult for a non-attorney to hit all of those. So
It is.
he gave it a shot, but the court basically said that this is
Already
barred
decided.
because of your first lawsuit.
Right.
So
Get one bite at the apple. That's it.
that's it. That's it. And I think it's relatively difficult. I mean, courts can enter a consent decree and apply certain requirements. If the numbers aren't working out the way that the parties originally agreed, they can go back to court and ask that it be reorganized. But for a third party to sort of interject themselves in that, I think if he was genuinely concerned about it, he should have been able to go back to some of the parties that were involved in it and get them to, ask the court to tweak the consent decree. But to try to file a separate litigation to challenge it is probably not going to be productive. So
that's it for the week.
All right. Well, Brad, we'll see you later this week in Verona.
Oneida, New York, at the Turning Stone Casino for our 17th annual conference.
All right. I'm looking forward to it. I'm looking forward to seeing you and Chip there, and we'll see. Yep, we'll see everyone next week.
Take care, everyone.
Edition of Fire Law.